Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And a little bit early today, I gave you all a lawsuit update and some insights into the Ripple v SEC lawsuit in terms of settlement. But now, looking at the case, I noticed there's something else which just happened. It's basically John Deaton coming in to request something from the court, and it's very freaking interesting. So today, I want to talk about that. Having said that though, guys, make sure you press that like button. It helps the video perform just a little bit better in the YouTube algorithm, and it doesn't cost you anything. Let's read it. Alright, so I want to read actually the full thing because it's about 1 page long, and John Deaton over on his Twitter said, it's basically just a very brief letter asking the judge to please consider the impact that a delay has on XRP holders. Now, for all of you that do not know, this is a reply to basically... No, let's actually do 2 steps back. This is John Deaton following through his right to give the judge advice. A little bit earlier, John Deaton filed for a motion to intervene. That was actually already months ago. Now, let's say a little bit earlier, so about a week ago or so, John Deaton got it granted that he could not intervene but act as a friend of the court, amicus curiae, if I remember the name correctly. Now, what that basically means is that whenever he feels the need for it, he can advise the court, or whenever the court thinks it's necessary, they will ask John for his opinion. And of course, there's a couple of others there too from his law firm. Now, right now, John feels as if the situation impacts him potentially, or the XP holders, but most importantly, he thinks he can add a couple of wise words where basically the XRP holders can kind of show themselves for, and so he's doing that. And it's a reply or a piece of advice after the SEC basically filed for an extension, and John Deaton is now replying to that. So, after significant deliberation and hesitation, coupled with the fear of annoying the honorable court, let's actually zoom in, on the heels of the court's order granting Moven's amicus curiae status, I respectfully request the court consider the perspective of XRP holders as it relates to the Securities and Exchange Commission's requests for a 2-month extension. SEC letter number 389, pursuant to the honorable court's order. XRP holders shall be allowed to assist the court by briefing legal issues relevant to the case as approved in advance by the court. Although Your Honor made clear that the court contemplated that such assistance will be mostly beneficial during briefing on dispositive motions, it was noted that the court may also exercise its discretion of request or denying further applications as it deems basically appropriate. Now, XRP holders respectfully request an application for the court to consider their meaningful perspective to aid the court in reaching a proper decision. Due to the time-sensitive nature of the SEC's letter requesting a 2-month extension, please accept this letter to serve as both the application for XP holders to offer their perspective as well as an offer of proof of said perspective. Accepting our limited role and participation, XRP holders waited until defendants Ripple Labs Inc. submitted its response to the SEC's extension request. XRP holders will not repeat any arguments or statements offered by Ripple and will be concise in offering our unique yet vital perspective for the court's potential consideration. Prior to the court's October 4th order denying intervention but granting amicus curiae, XRP holders proposed intervention as a class. Class certification was opposed by both the SEC and Ripple. Both parties argued class certification would delay the case. Based on Ripple and the SEC's objections, XRP holders conceded that any attempt to certify a class of defendants may cause such a delay. This concession was significant for XRP holders, but a major argument offered by the SEC in its opposition to the motion to intervene was that the intervention would hopelessly delay this action. That's also, by the way, what the judge actually agreed with, that an intervention would definitely stall the entire case and would make it last even longer. Now that the intervention has been denied, the SEC seeks a 2-month delay regardless, which of course is kind of peculiar. In opposing the SEC's request for this delay, Ripple's argument focuses on how the freezing of XRP markets within the United States impacts Ripple. The negative impact on XRP holders is even more profound. As the court is aware, nearly every digital asset exchange in the US has delisted or suspended trading of XRP. And in addition, to owning XRP on those exchanges, many XRP holders hold XRP in retirement brokerage accounts, and the XRP in these accounts have also been frozen due to the SEC enforcement action alleging XRP to be an unregistered security. Now, the lack of liquidity within the US, coupled with the mass delistings, prevent XRP holders from trading, selling, transferring, or converting their XRP, and it is because of this de facto in-place seizure of their property that XRP holders took the extraordinary step to seek intervention as defendants, effectively requesting that the court compel the SEC to take enforcement action against them. Any delay in the underlying actions marks yet another day XRP holders do not have access to their funds, and I wish to re-emphasize my hesitation in writing this letter out of fear that I may be stepping outside of my limited role. And I certainly do not wish to aggravate the Honorable Court in any manner. And with that being said, as this case proceeds to the merits, I hope even if the court denies consideration of this request, the court will understand why I was compelled to submit this request. By John Deaton. Okay, it's a little bit difficult for me to react to this because obviously this is one of the first things we've seen of this nature, and so I'm not really sure if this is normal or not. By the way he wrote it, I do like, let's say, his point and the bullets basically, which he has right here. Because of the way he wrote, I notice now that this is not a normal request and that he doesn't really know if this fits within the boundary of him just trying to basically advise stuff or not. Then again, what he is advising on is a very popular matter, and the fact that he is doing so does make me kind of happy because ultimately the underlying thing which he is fighting for is basically the unvalidated or ununderstandable delay of the lawsuit yet again. He doesn't really understand why the SEC can delay the lawsuit for 2 months, where when John Dean asked to intervene, they said no, because it would actually make the case last a lot longer. The only argument to make is that when John Dean was supposed to enter, they were basically afraid that it was going to add a lot of negativity for the SEC because they called it unduly burdensome, so to speak, in terms of time. But this, when the SEC wants to extend because they want to depose certain experts, they're calling it fine. It's interesting, all right? It's very interesting the way that this is moving, and ultimately we can't really do too much about it except for, I guess, just waiting it out and seeing how this is going to flow through. That's, I guess, all we can really do right here. Now, one footnote that I wanted to quickly note you guys on was this one right here. At the time of filing XRP holders' motion to intervene, over 12.6 thousand XRP holders had contacted counsel for movements. And as of October 19th, 2021, more than 50,000 XRP holders have contacted the undersigned counsel asking to be part of the putative class. It's actually really freaking interesting if you start thinking about that. That 50 freaking thousand XRP holders are done with what the SEC is doing. And again, remember guys, it's not just one thing. It is not just this lawsuit that we're sad about. And even if it is, the lawsuit has many different parts that you can be sad about or just not understand. But most importantly, in my opinion, it's outside the lawsuit. It's the way that the SEC has been acting. It's basically why Ripple got sued, but also why other crypto projects did not get sued and why other crypto projects like Ethereum are getting some preferential treatment or just some odd treatment, basically. How could and why is it that Joseph Lubin is so basically positive towards crypto? How could that be? What makes that happen? It's so strange for me. And I'm not talking about crypto generally. I'm talking about crypto regulations and working with the SEC in that sense. How could he be so positive? How could he know? And what does he know? I keep wanting to kind of know more about that stuff. It's so vague to me. But that's, again, an important point that we're fighting for, which a lot of XP holders are here for, obviously. And that's besides the point, I guess. Another important part was that I gave you guys a small lawsuit update earlier, which was basically this number 391, right? The document number. Now, a lot of people were confused saying, Dusty, you covered the wrong thing, you dumbass. This is what you're saying is something completely different from the lawsuit update, yada, yada, yada. No. The way that I get it now, right? Don't quote me on this, but the way I get it now is that there was basically two things happening. John Deaton filed this specific letter, the Deaton Law Firm LLC here, October 19th, SEC v. Ripple part. However, at kind of the same time, there was a Notice of change of address filed by some party, we don't really know who. And as I get it now, a notice of change of address is either, because that could be what John Deaton used to file this request because he just doesn't know what to do, or because there was basically some party who changed address almost at the same exact time. Now the problem is, guys, you have to buy this on Pacer, and I would gladly buy it for any amount of money that it would take. The problem is you just cannot do that. You need to be a lawyer to be able to use Pacer, which is very annoying, and I don't even know exactly why. But there's not really any way around it for me to, show it to you guys. Otherwise, I would. But on the document library here, it doesn't really show anything from today. That's why I'm assuming it's not really a huge document or not important, or that John Deaton used that number to file his own document. Then again, looking at the perspective of there not being any document number at the top here, I'm thinking it's just a side note. And the fact that he doesn't know whether or not he can actually file it anywhere and whether or not it's the appropriate manner also makes me think it's not the case. We can actually quickly see if there's any... no. Never mind. I thought, let's quickly see if there's also any other part of the change of address. There is not. Okay. So I guess this is it. And then again, guys, I'll quickly remind you all, there's a $3,500 bonus on BITRUE right now for a little bit. You might want to check it out. A link is down below. It's the biggest bonus yet, I think. I think it's the biggest bonus ever over on BITRUE. Check it out. A link is down below. And also check out my second channel. Going to be posting one trading video on there every single day. Hopefully so you guys can earn some freaking money in the trading realm as well. It's getting a lot of subscribers. It's doing really, really well, the channel. So go check it out. A link is down below. And I'll see you guys again in another crypto video later today.